Hey guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Legal Article India, Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017. So this is the second part of the video. Although the claims under the Admiralty jurisdictions is enlarged, the enforcement of the maritime claims by an actions in rem has been narrowed down under the Admiralty Act. Arrest of vessel owned by time charterer and voyage charterer in respect of maritime claims against them inconspicuously absent from the new Act. In example, Article 3, Section 2 of the 1999 Arrest Convention does not find a place in the Admiralty Act, which give rise to issue in this behalf and in relation to enforcement of maritime claims against time or voyage charterer in India. Sections 5. Part 1 of the Admiralty Act inter alia provides that a vessel can be arrested only if 1. Person who owned the vessel at the time when the maritime claim arose is liable for the claim and the owner of the vessel when the arrest is affected, or 2. The demise charterer of the vessel at the time when the maritime claim arose is liable for the claim and is the demise charterer or the owner of the vessel when the arrest is affected, or 3. Any other vessel in lieu of vessel above, subject to the provision of 1 and 2 above. The above provisions of the Admiralty Act and its diverge from the Arrest Convention has led to questions or issue relating to arrest of ship or sister ship for claims against time charterers, which issue is presently pending for decisions before the Bombay High Court. Section 5 permits sister ship arrest, but what the sister ship is would be subject to Sections 5, Part 1. Consequently, beneficiary-owned ship arrest is not permissible in India. Section 6 of the Admiralty Act also confers Admiralty jurisdiction in personam in respect of certain maritime claims, subject to certain restrictions as contained in Section 7. Under Section 7, for claim arising out of collision and related claims, and in personam action can be initiated against the defendant only if the cause of action wholly or in part arises in India, or if the defendant at the time of commencement of the action actually and voluntarily resides or carries on business or personally works for gain in India. For the first time in India, by legislation, the Admiralty Act defines maritime lien under Sections 2 and Part G, and they recognize certain claims as maritime liens and set out the priorities in Section 9. The Admiralty Act also specifies the period of limitation for maritime lien and states that the maritime lien shall stand extinguished after expiry of 1 year unless the vessel is arrested or seized, and such arrest, seizure has led to a forced sale by the High Court. However, in respect of maritime liens relating to claims for wages or other employment-related payment, including costs of repatriation and social insurance contribution, the limitation period is 2 years. The period of limitation would run continuously without any suspension or interruption, except the period during which the vessel was under arrest or seizure, which time is to be excluded. Likewise, the Admiralty Act also provides for priority of maritime claims in Admiralty proceeding in Sections 10. Maritime liens have the highest priority, followed by registered mortgages and charge, and thereafter all other claims. If there are more than one claim in any single category of priority, they shall rank equally, and salvage claims rank in inverse order of time to when the claims accrued. The Admiralty Act empowers the High Court to order the plaintiff seeking an order of arrest to provide counter-security either at the time of arrest or to continue an arrest. These provisions for the plaintiff to provide security is to cover the vessel owner if the event the arrest is held to be wrongful or unjustified or exercise security has been demanded or provided. Recently, plaintiff gave a written undertaking to the court under the Admiralty rules to pay such sums that the court may award as damages in case any party sustain any prejudice by the order of arrest of the vessel being obtained by the plaintiff. Under the Admiralty Act, in addition to such written undertaking under the rules, court can order the plaintiff to furnish security, which has been introduced to curtail wrongful arrest and or demands for exercise security, which would be beneficial to vessel owners. The High Court is empowered to auction on and sell a vessel that has been abandoned by the owner within 45 days of such arrest of abandonment, which may be extended by the further period of 30 days for reasons to be recorded by the court in writing. This would obviate an indefinite wait for the vessel to be sold by the court post arrest with no one entering appearance for the vessel and or arranging her release. Outstanding issues and anomalies of the Admiralty Act. The Act provides for rules to be framed for the purposes of the Act, which as yet still date to be framed, until such times as the rules are framed and notified in the official gazette. The existing rules of the relevant High Court shall continue to be applied as appropriate. Although the Admiralty Act is the first step towards codification of the Admiralty jurisdiction and related practices and rules follow under Indian law, the Admiralty Act has led to certain anomalies which are yet to be addressed by the legislature or the judiciary. One such issue is in respect of the respective application of the Admiralty Act under Section 17, which provides that all Admiralty proceedings pending in any High Court immediately before the commencement of the Admiralty Act are to be adjudicated by such court in accordance with provision of the new Act. There is no saving provision in the Admiralty Act that protects proceedings initiated before the Admiralty Act came into existence on 1 April 2018. Another issue is that by virtue of the Admiralty Act, the issue of whether a damp barge can be arrested and whether the court can exercise its jurisdiction over Indian vessel is put to rest. However, by operation of Section 17, all such pending applications are rendered infructuous, in example pointless. This issue is yet to be addressed by the court or the legislature. Likewise, there are other issues and trading problems. For example, some of the coastal high court have never exercised and or dealt with Admiralty cases before the advent of the Admiralty Act and would have to put in place inappropriate procedures for arrest, which is still not done as of date. Courts would be called upon to address the issue in due course in appropriate cases, which should then bring about more clarity and definitiveness to this new act. From this Admiralty Act, it will be noted that this same pertains only to arrest of vessel and does not permit arrest of cargo, freight, or bunkers under the Admiralty jurisdictions of the High Court. So this is the end of the article. Don't forget to watch the previous video and also don't forget to like, comment, and subscribe. Bye!